welcome to the Deep Dive. Today we're really getting into the weeds of a fascinating legal situation from Guernsey's royal court. It involves a defendant, William King, found unfit to plead.
Yeah, and the core mission here is understanding this incredibly tricky balancing act. How do you protect the public from potentially dangerous acts
Right.
when the person involved can actually be tried in the normal way without violating their fundamental human rights, specifically the right to liberty?
And that's Article 5 of the European Convention on Human Rights, the ECHR.
Exactly, which Guernsey law respects through its human rights law from 2000. But the problem started with a much older law.
Which one was that?
The Criminal Justice Special Verdicts, Guernsey Law, 1961. And let's just say the court itself pointed out it's pretty outdated.
Okay, so we have the defendant, Mr. King. He's found unfit to plead by the ordinary court back in May 2024. What does this old 1961 law suggest should happen then?
Well, the 1961 law points towards something called a detention at His Majesty's pleasure order, a DAH-MP order.
Meaning indefinite detention. Maybe at a place like Les Overlands.
Potentially, yes. But here's the massive problem. The court immediately saw that just issuing that DAH-MP order, locking someone up potentially indefinitely before establishing whether they actually did the acts they were accused of. Well, that would fly right in the face of Article 5.
Oh, I see. You can't just detain someone because they're unfit. There has to be a finding they did something dangerous first. Is that it?
Precisely. Article 5 is very clear. Deprivation of liberty needs a lawful basis connected to proven conduct or specific conditions, like conviction or proven mental disorder requiring detention. Just being unfit isn't enough on its own for indefinite detention related to alleged acts.
So the court had to kind of pause the process.
They did. They basically put the DHMP decision on hold and convened the full court for a special hearing.
And the purpose of that hearing?
Solely to determine the facts. Did Mr. King carry out the acts alleged against the complainant, known as C?
And did they reach a conclusion?
Yes. On July 24th, 2024, the full court made formal findings. They found that Mr. King had committed acts of false imprisonment, that's a customary or common law thing, in Guernsey, and sexual assault, which is under their 2020 law.
Now, you use the word findings. Why is that distinction so important here for people listening?
It's absolutely critical. Because he was found unfit to plead, these findings are not convictions. There's no finding of criminal guilt, no criminal record in the traditional sense, and crucially, no punishment.
Okay. So it's not about punishing him.
Not at all. It's a specific legal step they had to take. Think of it as a fact-finding exercise required by human rights law, specifically Article 5, to establish the risk he posed. Only then could they lawfully consider measures to protect the public.
Got it. So the findings unlock the door to protective measures, but not to punishment. Let's talk about those acts the court found he committed. What happened?
Well, the judgment lays out some pretty disturbing details. On April 23rd, Mr. King was acting as an unlicensed taxi driver. He picked up complainant C, who was quite drunk. He dropped off someone else, but then drove C around for about 2.5 hours.
2.5 hours. That seems excessive.
It does. The court noted the initial part of the journey might have been consensual, but things changed dramatically when they parked at a place called Icart.
What happened there?
C woke up. She found Mr. King partly on top of her, or sort of half in the car with her. Her pants were down, trousers partially off. That was the basis for the sexual assault finding.
Right. And she tried to get help.
She did. She screamed, tried to dial 999, but the finding was that he grabbed her phone. And then even though she was screaming for him to stop the car and let her out, he didn't for some time.
And that's the false imprisonment finding.
Exactly. And the evidence wasn't just her testimony. There was CCTV, phone location data, and apparently very distressing dashcam audio.
The judge mentioned that specifically.
Yes, noted it was harrowing footage to listen to, recording her screams.
Wow. Okay, so the acts themselves are serious. But did the court look at anything else when assessing the future risk he might pose?
They did. And it adds another layer of concern. The judgment mentions that just before he picked up C, Mr. King had been looking at pornography online.
Okay.
And this included, disturbingly, borderline images of children and also a video involving bestiality. Plus, all this happened while he was actually on bail for a different complaint, although that was later withdrawn or amended.
So you have the serious acts against C, the concerning online activity. The court needed expert input on the level of risk, right?
Absolutely. They had two key reports. One from Mrs. Golden, a probation officer, and one from Dr. Radley, a consultant psychiatrist.
And did they agree on the level of risk?
Not entirely, though. The difference was maybe more in the labeling than the substance. Mrs. Golden used a specific tool, the RSVP-V2, and concluded the risk was high.
High risk of what, specifically?
A real threat of serious sexual harm, particularly towards vulnerable females. And she noted that his internet searches suggested this could potentially include female children. Her recommendation was pretty stark. Off-island treatment in secure conditions. She felt the risk couldn't be managed safely in the community.
Okay, that's a very serious assessment. What did Dr. Radley, the psychiatrist, conclude?
Dr. Radley assessed the risk of sexually inappropriate behavior as moderate. But importantly, she added a significant qualification.
Which was?
She said Mrs. Golden's high-risk assessment was, quote, justifiable if there weren't strong mitigating measures put in place. So while the labels differed slightly high versus moderate, both experts agreed treatment was essential and the underlying risk was serious and needed managing.
Right. So faced with these findings and the expert consensus that treatment and management were vital, the court still couldn't just punish him or lock him up indefinitely under the old law because of Article 5.
Exactly.
So how did they create a framework to actually protect the public? This is where the legal innovation really comes in, isn't it?
It really is. They turned to a different piece of legislation. The Sexual Offenses, Bailiwick of Guernsey Law, 2013. Specifically, the Provisions for a Sexual Offenses Prevention Order, or SOPO.
And an SOPO that can be applied even without a criminal conviction.
That's the key. A SOPO can be made if the court is satisfied the person poses a risk of sexual harm and the order is necessary to protect the public from that harm. The findings they'd made were enough to meet that threshold for the sexual assault element.
But what about the false imprisonment? That's not usually a sexual offense, is it? How do they bring that under the SOPO?
Good point. False imprisonment isn't automatically a relevant offense for a SOPO under that 2013 law, so the court had to take another step. They had to formally certify the false imprisonment finding as being sexually aggravated.
How did they justify that?
They reasoned that because the false imprisonment happened immediately after the sexual assault finding and was essentially part of the same incident, directly linked to preventing her escape from that sexual context, and given the overall risk profile, it met the criteria for being sexually aggravated.
Wow. Okay, so that certification allowed them to base the SOPO on both the sexual assault finding and the sexually aggravated false imprisonment finding. It broadened the scope.
Precisely. It gave them a stronger legal footing for the comprehensive restrictions they needed.
Let's talk about those restrictions. What kind of conditions did the SOPO actually impose? They must have been quite detailed.
Oh, extremely detailed. They fall into two categories. Things he's prohibited from doing and things he's required to do.
Okay, what are the main prohibitions?
Well, first, he's banned from being in a private vehicle with any female unless it's his mother or unless the probation service gives specific prior approval.
That's a major restriction on movement.
It is. Second, he can't use or even possess any mobile phone, tablet, computer, anything that connects to the internet unless the probation service approves the specific device first.
And I remember reading something about deleting history.
Yes, critically, he is absolutely prohibited from deleting or hiding his internet usage history, browsing history, call logs, anything like that, on any device the probation service does approve. That allows for monitoring.
Okay. Any restrictions regarding children?
Yes. No unsupervised contact, direct or indirect, with any female under the age of 16.
So those are the don'ts. What about the must-dos, the requirements?
These are about ensuring compliance and treatment. He must live permanently at an address approved by probation and tell them in advance if he moves.
Right.
He can only take up work, paid or voluntary, if probation approves it first. He must comply with any programs or requirements probation sets up to address his sexual offending behavior.
So compulsory treatment programs.
Essentially, yes.
Oh.
And he must attend every single appointment for psychiatric assessment, treatment, or offending behavior work. No skipping allowed.
That sounds like a very tight net of supervision and control. How long is this SOPO in place for?
The court set it for 5 years, starting from January 17th, 2025. They considered proportionality, balancing the risk against the fact he wasn't convicted.
Okay. And did this also trigger notification requirements, like being on the sex offenders register?
Yes, it did. The court was very clear. For the purposes of the 2013 law's notification requirements, these findings are treated as equivalent to a conviction.
So he has to register with the police?
For 5 years, yes, until January 18th, 2030. That means the standard things: telling the police his address, notifying them 24 hours before any change and giving them 7 days' notice if he plans to travel abroad.
So putting it all together, the court, faced with an unfit defendant and an outdated law, had to use this complex two-stage process. First, establishing the facts through findings, then using those findings, plus some clever legal certification, to impose a really restrictive SOPO and notification requirements under different law, all to satisfy Article 5.
You've got it. It's a bespoke solution, heavily reliant on a very recent precedent from just earlier in 2024, a case called Law Officers of the Crown VYP. It shows the judiciary actively creating pathways where the legislation is lacking.
It really highlights how legal systems, even in places like Guernsey, have to adapt when old laws meet modern human rights standards.
Absolutely. It forces innovation, but it also exposes the underlying problem.
And the judge seemed to acknowledge that directly.
Very much so. The final sentence of the judgment includes this specific statement from the judge of the royal court. I record that the 1961 law is in urgent need of reform.
That says it all, really.
It does. And that, for you listening, is probably the key takeaway. This whole intricate process, the special hearing, the findings, the certification, the carefully crafted SOPO, it was all necessary because the primary law was broken, fundamentally incompatible with human rights standards in this situation.
The court had to essentially build a bridge over a legislative gap.
Right. Which leaves us with a final thought, doesn't it? When someone is found to pose a significant risk, but can't be held criminally responsible in the usual way, the state still has a duty to protect the public.
But also a duty to respect the individual's rights.
Exactly. The court found a lawful path here, compelling protection and treatment, but it relied on judicial creativity, patching over cracks in a law that's over 60 years old. What responsibility does the legislature have to proactively fix these outdated frameworks rather than leaving it to the courts to navigate these complex human rights issues case by case?
Something to definitely think about.